Good morning. Can I welcome everyone to this, the 9th meeting of the Justice Committee in 2014. I ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent. Sandra White's unable to attend today. You'll be pleased to hear because she's got a dreadful cold and we don't want you to get it, Alison. It was on your behalf. Item 1. I want to ask the committee if you agree to consider our work programme and the further draft response to the Standards Procedures and Public Appointments Committee inquiry into legislation procedures under items 4 and 5 in private. Would you agree? Item 2, Courts Reform Scotland Bill Stage 1 Evidence. This is our main item of business today, and it's our first day of evidence at Stage 1 of this bill, and we'll hear from members of the Sheriffs Association. But for now, I welcome to our first panel Fred Tyler, Member of the Civil Justice Committee, Law Society of Scotland, James Wolffe QC, Dean, Faculty of Advocates, Julia Clarke, Principal Advocate of Which, and Lauren Wood, Policy Manager, Citizens Advice Scotland. And we move straight to questions, please. Margaret, followed by Elaine. Roddy, was that a hand gesture? No? Right, thank you.
Good morning, panel. I wonder if I can ask you all your opinion on the bill, its provisions and its impact on access to justice and equality of representation.
So a general sweep. Just self-nominate and your microphone will come on automatically. Mr. Wolffe.
Yes, thank you very much. And thank you very much for the opportunity to give evidence to today. Can I say immediately that the Faculty of Advocates welcomes the opportunity to modernise Scotland's court system. There is a serious job of work to be done, and it's in everyone's interests that justice, civil justice, should operate in a manner which is produces just outcomes within a reasonable time and at a reasonable cost. And I certainly welcome the many of the proposals in the bill which are designed to improve the sheriff courts as a forum for civil justice. I welcome the proposal for the introduction of summary sheriffs, and I welcome the proposal to introduce Shrieval specialism. So far as access to justice and equality of representation is concerned, I have concerns, and those concerns are particularly related to the increase in the exclusive jurisdiction of the Sheriff Court. It's perhaps important to understand where we are at present in terms of access to justice and equality of representation, because at present in the Court of Session we have a system which works effectively, particularly in the context of personal injury cases. And I think it will be important that the committee separates out the particular issues relating to personal injury cases from other types of case. I recognise immediately that, and I've produced statistics myself that show that there is in the Court of Session a body of personal injury claims which, while important and significant to those who are pursuing them, are nevertheless at the lower end of the value scale. Now, that's an issue which doesn't, as far as I understand it, apply in relation to other parts of the work. At present, in relation to personal injury claims in the Court of Session, pursuers are able to instruct counsel. They're able to instruct counsel on a speculative basis, which means a no-win, no-fee basis. This means that the pursuer has the benefit of effective and skilled representation, effectively at no cost to the pursuer, because if the pursuer loses, there's no fee. If the pursuer wins, then the fee will be met as part of the award of expenses. Now, if we have a shift of those cases to the Sheriff Court without an ability, in effect, for the mechanisms under which that system can operate to be transferred with those cases, then, and if we create an environment in which counsel cannot be instructed by pursuers in that way, then there will be a diminution in access to justice, and there will also be a diminution in the equality of representation.
Sorry, I take it you're referring to sanction of counsel in Sheriff Court from the point of view of awards of expenses, if you could perhaps explain that.
Yes, it's perhaps important to understand that in the Court of Session, the parties have a right to instruct counsel, and if in the ordinary course, if you get an award of expenses in your favour, then the fees of counsel will follow success as part of the award of expenses. In the Sheriff Court, while everybody is free to instruct counsel, an award of expenses will not include counsel's fee unless the sheriff has said, given sanction for the use of counsel. So in effect, the sheriff, in practical terms, decides whether the litigant, in effect, ought to have counsel or not. Now, if in the transfer of cases from the Court of Session to the Sheriff Court, we have a system in which counsel cannot routinely be instructed because of the particular rules about expenses in the Sheriff Court, then there will be a diminution in the ability of ordinary men and women pursuing these types of cases to instruct counsel, and that will have an effect on the equality of representation.
To amend the bill to now enable counsel to be instructed?
Well, I think there are perhaps two ways of looking at it. One is that there's an issue about what the right number is, because there are separate points that are made by various people about the, as it were, the quality of justice in the Court of Session. But certainly it would be my invitation to the committee to say that if the cases are, if we'd have a structural shift of cases into the Sheriff Court, then counsel should be able to follow those cases, and litigants should be able to instruct counsel without artificial restrictions on their ability to do so.
Is there a step before that? We're looking perhaps at the threshold and the number of cases that are likely to shift. Is there some suggestion you have to improve that, or are you happy with the 150,000?
No, I would still say the 150,000 is far too high, particularly when one looks at comparable jurisdictions. In Northern Ireland, the relevant limit is 30,000. And in fact, if a case is worth more than 30,000 in Northern Ireland, it has to go to the High Court. It's not a question of an option. Mm-hmm. In England and Wales, the basic rule is 25,000, as I understand it, but for personal injury cases, it's 50,000. And so the 150,000 in my submission is far too high. And it's important in thinking about what the right number is to, again, separate out personal injury cases and other cases. If one looks at personal injury cases in the Court of Session, and one looks at the data, I accept immediately that if one looks at the settlement figures, 70% of the personal injury cases in the Court of Session settle for a figure of £20,000 or less on the figures that I have, which are not, of course, by any means a complete set. The bill will have built into it robust measures to discourage people from bringing cases that are low value or that are worth less than exclusive competence in the Court of Session. And if those measures work, then one would expect people, solicitors and counsel, to be careful about the way they take cases into the Court of Session. Now, if those measures work, then one could achieve a substantial shift of cases at a level of, let's say, £20,000. if one is looking for an international comparison, well, Northern Ireland has a figure of 30,000. That builds in some allowance for what...
When did that figure of 30,000, when was that? You've given us sort of top lines for various other parts of the UK. When were these figures relate to? What period? I mean, are they fairly recent?
In Northern Ireland, they increased the number from 15,000 to 30,000 last year. I'm afraid I don't know when the English figures were last changed. Yeah. Can I just say that it's important not to lose sight of the non-personal injury cases. In relation to non-personal injury cases, I recognise that there's a case for increasing the exclusive competence of the Sheriff Court likewise. But I'm not aware of any substantial evidence, or indeed any evidence at all, that non-personal injury litigants are making choices that might be thought inappropriate in terms of forum. And in particular, I'm not aware of any evidence that commercial litigants are choosing inappropriately to take cases to the Court of Session. And there is a real issue in relation to the non-personal injury cases about compelling litigants who at the moment, for reasons which are good to them, choose to bring cases to the Court of Session, to take cases into the Sheriff Court system at a time when we all recognise the Sheriff Court system requires reform, and we all recognise that reform is going to take a period of time, 10 years, I think, is the Scottish Court Service's estimate. So on the non-personal injury side, I would suggest that an increase equivalent to the Northern Ireland figure of 30,000 would be a sensible figure, and that could be reviewed as the Sheriff Court reform process goes forward. That would create, if I put it this way, it would move the exclusive competence in a way that marches with the progressive nature of the Sheriff Court reforms.
If I could just...
Ms Wood, I think, wants to come in as well, so I was going to...
It was just that little point.
Okay, then I'll let Ms Wood in. Thank you.
As I understand it from your submission, if it was the 150,000 threshold, that would only be 9% of cases going to the Court of Session. And in fact, just now, only about one case has ever got anywhere near the 150. So if I understand what you say, Mr Wolffe, what was the definition? Yeah. Definition. Sorry. If I understand what you say, then given we've got court reform and you know, issues around whether it's able to cope with it, the Sheriff Court, it should be more gradual, shouldn't be the 150, somewhere around 30,000 would be manageable and would probably be an improvement.
In short, yes. I think the 9% is the personal injury cases. The one case is defamation, an example from defamation.
I'll let Ms Wood in. Thank you. You've been very patient, and I'll take Ms Clarke. Ms Wood.
Thank you for inviting us along today. I think we come at this from a bit of a different angle than James. In terms of the bill, we certainly welcome the bill, and I think it is a really key instrument in taking forward the programme of reforms that will happen. I think in particular we welcome the specialisation of sheriffs, the summary sheriffs and simple procedure, which will make a big difference to a huge number of users of the court system. I don't think it should be forgotten that this bill is part of a much wider picture of reform to the civil justice landscape in Scotland. The court system is one element of the delivery of justice, but in terms of the way that a lot of people approach the problems they have, the courts aren't necessarily the place that they expect or want to end up when they have a...
I'll know that here.
Yeah. and so
grannies and sucking eggs here, you know. So I appreciate you doing it for the record, but
yeah.
we do realise that.
And there will be reform that goes on, we hope, to the preventative side of justice to stop a lot of cases getting into the court system that shouldn't get there. I think it's important in the context of this bill also to think about what we're aiming for at the end of the process. And a lot of the thoughts on representation, for example, are very tied to the system that we have now. And the system that we're aiming for should be a much more progressive system, and it should be a much more proportionate system. In terms of I suppose, balance of representation. I think one example we have to have in mind of a balance that's swung too far the other way is employment tribunals. And I think that would always be the caution that I'd have in my head when we talk about counsel in the sheriff court system. I'm sure at times there is a place for counsel, but in the employment tribunal example, it's gone from a forum that should have been accessible in person to parties to a situation now where regularly counsel is instructed against a party litigant or a lay representative. And I think it is important to have proportionality, but proportionality doesn't necessarily mean that you need proportionality of the most extreme form of representation.
Surely what Mr. Wolffe's suggesting is that it would be the pursuer in personal injuries who'd be entitled to, in his view, a counsel, and they would be pursuing against, and generally in personal injury, employers. So it would seem to me that that would assist the ordinary people, as it were.
I think that is possibly true in the context of personal injury cases, but there are a lot of other cases that we can't lose sight of. I think James is right to say that the discussion can't just be about personal injury. There is a lot of other things that will be affected by similar discussions.
So where it wasn't counsel for either side, and it was maybe more different representation for both sides. Is that what you think would come out of the bill that would be good for just generally improving access?
I think, well, I suppose that a lot of the experience that the Citizens Advice Service have are in terms of the lower value claims. So the things that will fall under simple procedure and will fall to summary sheriffs. And I think in those terms, in the lower value claims, the rules should be such that people should be able to represent themselves. It should make it much more easy for party litigants to be involved. And so focusing on those lower claims under the simple procedure, yes, I think there should be an assumption from the start that there isn't counsel involved, and there's not necessarily lawyers involved.
I mean, I have to, it's a long time since I was in practice, but in the small claims court, I can certainly recall party litigants and the sheriff being really very gentle with party litigants and making allowances for them telling a whole narrative that practically had nothing to do with the claim, and being quite tough on the lawyer representing the other side. So does that not already happen to some degree? You talk about inquisitorial. My experience, as I say, is old now, but does that not happen to some degree now in small claims?
I think
sheriffs tend to help party litigants?
To some degree it does, and some of the time it can depend on which sheriff you have. Small claims was a process that, when introduced, aimed to be much more open than even it is now. So it started as a process where the sheriffs were to come and sit round a table with claimants and to not wear wigs and to not wear gowns. And that, I think, from speaking to different people who were involved in it as the years have gone on, it did start off as an intention, but then the sheriff started to sit behind the bench and they started to sit with their wigs and sit with their gowns. And so when the sheriff is on the bench, they may take an approach that's much easier for people. But what I'd also say is the aim of the ethos that they were designed to be there is slightly lost to the fact that, in Edinburgh Sheriff Court, for example, when you go through the door, you have to go through a metal detector. There are police guards standing. You've got to walk past the criminal courts to get to the civil court, which is on the upper floor. It's a very daunting experience.
Good reason for going through security, we have to admit. Can I accept that? I want to, Ms. Clarke, you indicated you wanted to come in, then Mr. Tyler.
Yes, thank you. For us, the bill is all about proportionality, about people being able to access justice at the lowest cost and the most accessible process, really. So our particular interest in this is the inquisitorial system, the new simple procedure, which I think will make a great deal of difference to the consumer. Many consumer cases, more will go to court because of this, because people can better access this system. But we believe that the bill is very important in terms of proportionality, because people can prosecute their rights at the lowest possible level and the lowest possible cost. And that is really important. And that's why it's very important to move a great deal of the business out of the Court of Session and into the lower cost court, the Sheriff Court, where the processes are easier to understand for people, more easily accessible, and the cost is considerably lower. I think it's about a third the cost of going to the Court of Session. We would like to see many of the consumer cases dealt with in this inquisitorial system, an easy-to-access system, possibly not even in court, possibly just with the sheriff, the parties concerned, in a far less formal setting, possibly online, using far more IT systems. Some very fresh thinking applied to this. Many consumer cases are fairly simple. It's about, did you get the kitchen? Did your car not work? Did you get the holiday? And people at the moment are not able to access justice on many of these cases for this reason. We would actually like the ceiling for the new simple procedure raised to £10,000 as it is in England, because after all, consumers pay the same costs for consumer goods. However, if this can't be done at this time, we'd like to see it done later. We'd like to have the simple procedure reviewed and the ceiling put up to £10,000. But basically, people want to access justice at the easiest level and not... the process should be easy to understand and require as little help from lawyers as possible. We'd like to see lots of people presenting themselves as party litigants, and where they have help, to have the lowest level, the most proportionate level of support.
Just a wee minute, Margaret. There's other people waiting.
It was just asking that.
Because Elaine's waiting to get in as well, and I've got Mr Tyler wanting it, so let other people come in. Sorry, have you concluded that? Thank you. Mr Tyler.
Convener, the Society also welcomes the opportunity of coming along this morning and thanks the committee. And there is much in the bill which we support, and that has been made clear in our written submission. There's also a great deal in what the Dean of Faculty has said, with which the Society has a great deal of sympathy and agreement. It is accepted that the current limit of exclusive jurisdiction in the Sheriff Court of £5,000 is far too low, and that reform of the Sheriff Court is essential. But the Society considers that a change to £150,000 is a seismic change, as we've described in our written submission. The Society represents a broad church of solicitors, and on the one hand, the personal injury practitioners would be happy to follow the April line of a £30,000 limit, whereas some of the insurance practices would be perfectly happy with £150,000. The Civil Justice Committee has taken an informed view on the basis of all the evidence which has been provided by both sides to the debate, and it is considered that £50,000 would be an appropriate sum, with the opportunity of the Civil Justice Council and the Scottish Ministers thereafter to monitor how an increase to that level would go. We don't see that it would be necessary to increase beyond that at the highest level. In relation to access to justice, many solicitors are perfectly capable of conducting cases in the Sheriff Court at significantly higher value than £5,000, and some, but relatively few, I would venture to suggest at this stage, would be comfortable or confident in presenting cases at the upper level of £150,000. There is a serious issue of personal injury.
Yes, not other cases, contract or something.
There is, of course, also concern in relation to other cases. Defamation has already been mentioned, and insofar as our researches go, there's only been one case in the entire history of Scots law where the damages awarded have exceeded £150,000, and my understanding is that that case is currently under appeal. Defamation is a very highly specialist area. It's not one of the designated areas. There are specialists both at the bar and on the bench in the Court of Session, and I would be very concerned if defamation was sent to the Sheriff Court without the opportunity of a transfer. And I do appreciate that there are provisions for remit, but these provisions are indeed very restrictive, and that's one of the concerns that the Society has. If there were an increase to £50,000, then, as I indicated, there are many solicitors who are in a position currently, with their experience and level of training, to conduct these cases themselves. I think there would be a period between the introduction of a new level and more solicitors getting up to the sort of level where they would have the advocacy and pleading skills, which would mean that pursuers who are currently represented by counsel would be represented at a similar level. So I think there is a serious concern about the level of representation, particularly where insurance companies may be able to instruct counsel, and a pursuer, not knowing whether he will have sanction for counsel, will not know whether he's able to instruct counsel or not.
Thank you. Elaine, you wanted to...
Yes, some of the evidence we've had has expressed concerns about the sheriff courts already being overcrowded, and some witnesses have indicated that they felt that some of the proposals, particularly proposals transferring more cases into the sheriff court, is actually going to exacerbate what's already a difficult situation. And now I understand, obviously, the government might argue that they're going to have the personal injury courts specifically, but I understand that's only to have 2 sheriffs, and that the summary sheriffs will be appointed as other sheriffs retire, rather than adding to the capacity of the sheriff court system. So I wondered about your views on the current workload of the sheriff court, because I've certainly had constituents in family law cases had, cases adjourned without being, or not heard, people trekking down from Sankers to Dumfries and a case not being heard and so on. Is that going to get worse under these circumstances? Is there sufficient resource actually being put into the sheriff court system in order to be able to make this work?
Mr Townley, you indicate.
There's a considerable concern on the part of the society that unless sheriff court reform is properly resourced, then it is going to make an overcrowded sheriff court even more difficult. There's also a serious concern if there's a personal injury court with only 2 sheriffs, whether that can cope with the volume of work which would go to these sheriffs. It is far from inconceivable that, for example, in a clinical negligence case, the value will be less than £150,000, but it could tie up a sheriff for anything like 4 to 5 weeks. That is based on the experience of what happens in the Court of Session at the moment. And in that event, it is difficult to see how the remainder of the business in the Sheriff Court and the Personal Injury Court could be properly managed. So I think there is a very real concern that going with reform, there must be suitable resourcing, not only in relation to the number of sheriffs and summary sheriffs available to conduct business, but also in relation to the training of specialist sheriffs.
Mr Wolffe.
Yes, I would endorse those comments. And again, it's perhaps important to separate out the 2 issues, the personal injury work and other cases. So far as the non-personal injury work is concerned, the effect of the increase in the exclusive competence of the Sheriff Court will be to compel litigants who currently choose to come to the Court of Session to litigate in whatever is the appropriate local Sheriff Court. Now, I wouldn't want by any means to tar the whole Sheriff Court system with any brush at all, but experience reported by my members would suggest that for the more complicated contested litigation, the Sheriff Court doesn't do well, and that's one of the reasons why we support Sheriff Court reform. One has to appreciate that if one's thinking of the non-PI cases where litigants have chosen to come to the Court of Session, they're likely to have chosen to come to the Court of Session because the case, in their view, merits the Court of Session for one reason or another. Maybe it's a commercial case and they like to use the commercial court in the Court of Session. But one might envisage that these are likely to be at the more complex end of the scale. And one must have a concern that to take those cases into the Sheriff Court system at a time when the Sheriff Court system is being reformed, and reform is a process that's going to take some time, is not going to serve those litigants well. I do notice that the financial memorandum at paragraph 98, if I understand it correctly, suggests that the savings to the public purse of shifting the non-personal injury cases to the Sheriff Court are likely to be marginal. And so one must ask, if the savings are marginal, why to the public purse what the benefit is, given the issues I've mentioned. As far as personal injury work is concerned, as Fred has said, it is essential that the personal injury court is adequately resourced for the business that it receives. And I entirely agree with what Fred has said about the potential issues if that court's only to have 2 sheriffs.
Clarke.
Well, it was really just to pick up James's point that the savings to the public purse are one thing, and certainly those are welcome and valuable, but the savings to the consumer are absolutely crucial, and also to allow people to come to court who at the moment cannot pursue justice because of the costs. As to the £150,000 limit, unless it's a substantial limit, many more cases will not come into the sheriff courts, which goes to the proportionality of the system, which is what consumers require really in terms of access to justice. Another suggestion, of course, is that we do move some of the consumer cases, the simple procedure cases, into different settings. We open the courts after hours, we have weekend sessions. There are all sorts of ways we can do it. And the additional aspect of more specialisation will really help these consumer cases to be solved. The specialisation of sheriffs will speed the cases, the better case management will speed cases. At the moment, I take your point, Ms Graham, about the small claims, but it's patchy, and sheriffs do a very good job in small claims, but sometimes a party litigant is standing there and is asked, upon what point of law are you relying? And they look around blankly, of course, as any of us non-lawyers would do, and nobody knows, and the case is continued. So I think by putting that place and system that's accessible to people, we can really speed things up. And in fact, there is no particular reason why these cases should be part of this overall system. They could come out of the system and make way for the more complex cases, which we do understand must be remitted when they're more complex, and perhaps personal injury cases in particular.
Resource. I mean, I think that's the concern, not so much that it couldn't work, but that the resources actually aren't there in place to make it work.
It is an issue, and yes, I can understand concerns about it happening all at once. I can understand that concern, yes.
It's all right, Miss Wood, I see you. Don't be agitated. I know you want to come in. Yes.
I absolutely agree with what Julia has said. And I think there are concerns about particularly civil business being squeezed, and particularly in the bigger courts as the court closures programme moves ahead. I know in the past this committee has heard evidence about particular concerns in Aberdeen, for example. I think in terms of civil business, and again particularly the lower tiers, for example, something that makes a huge difference to party litigants and sheriffs themselves are the in-court projects and the lay representation projects, some of which are run by bureau across the country. Hand in hand with them, as part of a couple of those projects, is mediation, which has also proven to be largely successful. It was one of the recommendations made in the Gill Review that there should be these sorts of projects available attached to every court. And I would say that does strongly help both litigants and the sheriffs. I was in Edinburgh Sheriff Court on Thursday and sat in with the in-court advisor there, and he didn't stand up to speak necessarily for the party litigants who were there, but beforehand he did brief them on what would happen, where they should stand, and the points that they should make as part of the hearing at that level. And so when presented to the sheriff, the points were coherent, they were what he wanted to hear, and they were standing in the right place. It helped both sides in that case. And things like that, I think, can really take some pressure off when litigants have a much sharper idea of what that hearing is about for them. In terms of the recruitment of summary sheriffs, it's something that Citizens Advice Scotland feel should happen much sooner than just as sheriffs retire. Summary sheriffs will represent a new type of sheriff. They'll represent a much more accessible sheriff, and the ideals that we outlined in our paper, we would very much like to see in the practice of summary sheriffs. if the summary sheriffs are recruited as sheriffs retire over a period of 10 years, there's a very real danger that people who live in different parts of the country will have quite different access to justice depending on their postcode. And I think that's something that should be avoided.
Yes, Julia made one very important point which the Society recognises.
But,
well, I'm sure, but there's one upon, indeed she did, but there's one upon which I would like to pick up on behalf of the Society, and that is that savings to the consumer are important. And that is fully recognised, but I must emphasise that in personal injury cases, the vast majority proceed on the basis of no win, no fee, and there is no cost to the pursuer consumer. And I think that's a very important point to bear in mind.
I just ask, the reference is made to commercial cases, and I understand there's a bit of a concern also that under current proposals that some commercial cases which might currently be held in Scotland would migrate to the High Court because they would still be able to get up into that level of the judiciary.
It should come on automatically,
yes.
Mr. Wolffe.
Yes, sorry. Yes, that's certainly a concern that's been expressed by some of my members who specialise in commercial work. There is already a degree to which cases which could be heard in Scotland are heard elsewhere, particularly in London, and commercial litigants are often able to make choices about the forum in which they choose to appear, not least because they can, in their contracts, say that a dispute under the contract will be decided in a particular court. And I suppose the question one has to ask is that if a commercial litigant who's in that position is asked, do you want to go to the through the commercial court system in London, or do you want to litigate in your at the moment in your local sheriff court for any claim that's worth £150,000, then there is at least a risk that these proposals will discourage commercial litigants from using the Scottish courts.
So financial implication of that as well in terms of the court fees or whatever? Is there financial implications for the court system in terms of that business not coming into our system?
Well, indeed, in the long run, our legal system, which is an independent, separate legal system, depends on a body of case law coming through the courts for the courts to decide. And leaving aside any other issues, if we create a situation in which the Court of Session, as the Supreme Court of Scotland, is not hearing a sufficiently significant volume of difficult cases to develop the law, then in the long run, the law will be the poorer. I think the committee has got some evidence from the academic community expressing some concerns along those lines.
But difficult cases can always be remitted from Sheriff Court to Court of Session, even if it's not very high monetary value. Is that not the case? If there's some difficult or testing issue of law. So that wouldn't change.
I certainly recognise that. It's fair to say the provisions for remit are framed for cases below the exclusive competence extremely narrowly, because the way they're framed is to the effect that even if a sheriff considers that the importance or difficulty of the claim would make it appropriate to remit to the Court of Session, there still have to be exceptional circumstances. So it's a separate point of concern that the...
Now, if it's not exceptional circumstances then, because it can happen just now, what's changing?
I'm afraid I don't know what the current the terms of the current rule are, but I can perhaps come back to you on that. I'm just looking at the terms of the bill itself, which tell us that, as I read it, in addition to the importance of the and difficulty of the claim, there must also be exceptional circumstances.
I just wonder if it's a change from the status quo. Mr Tyler.
I believe there is a change in the sense that there is now a double test, because the sheriff has to find that there are exceptional circumstances, and then the Court of Session has to accept that there is special cause. The Court of Session also has to take into account business and other operational needs of the court, and there's a very big concern on the part of the society as to what that actually will mean in practice. Because if the Court of Session, for example, were particularly busy, a case may not be remitted on 1 week, and the next week, if the court is quiet, then a very similar case may be remitted. So I think that that is an area which is unclear and which requires clarification.
Thank you. Thank you. Roderick, I think you were asking to come in. I wasn't sure.
Yeah, indeed.
You're so subtle sometimes.
Yeah. Thank you, Convener. Can I first of all refer to my declaration of interest as a member of the Faculty of Advocates? I'd like to kick off, if I may, by just looking at this question of sanction for counsel. Sheriff Taylor reported last year, and although the Scottish Government has yet to reach a view on his report, in Sheriff Taylor's report, he recommended that the current test should remain one based on the circumstances of difficulty or complexity, or the importance or value of the claim, with a test of reasonableness also being applied. And he also recommended, when deciding a motion for sanction for the employment of counsel, the court should have regard, amongst other matters, to the resources which are being deployed by the party opposing the motion, in order that no party gains an undue advantage by virtue of the resources available to them. Could I ask, particularly the legal practitioners, for their comments on Sheriff Taylor's comments in that respect?
Yes. Can I say immediately that I very much welcome the, as it were, the change of tone on sanction for counsel from the government's policy memorandum, which suggests that a much higher test. I think the question one might ask, if there's going to be a structural shift of cases to the Sheriff Court, is whether a rule that restricts the use of counsel by reference to sanction by the Sheriff remains the right way to control costs of litigation. In effect, what that rule does is it limits the ability of litigants to choose to use counsel in cases where the Sheriff doesn't grant sanction. It limits the ability of counsel to offer their services across the board in the Sheriff Court. And I should say that Sheriff Principal Taylor's recommendations were made before a recent change in practice which allows counsel to appear in the Sheriff Court in appropriate cases without a solicitor having to sit behind counsel. So I would welcome a much more radical examination of the way in which counsel might be instructed in the Sheriff Court. If I put it this way, the rule on sanction for counsel, which doesn't have any counterpart in the other jurisdictions of the United Kingdom or in Ireland, limits the ability of solicitors to use counsel in the most flexible way. It limits the development of business models which seem to work well in the other jurisdictions of these islands, and indeed which seems to work well in the context of personal injury litigation in the Court of Session, where the solicitor chooses to use counsel routinely as a flexible resource in all sorts of cases.
Mr. Tyler.
Thank you, Convener. I think the principal difficulty for a pursuer, for a claimant, is that when he commences the case, he will not know whether or not sanction for counsel is going to be granted. In these...
I just interrupt, because I've not raised the issue of legal aid in this. Is this relevant as well, obviously?
Well, the Legal Aid Board will no doubt look very closely at whether in the legal aid system sanction will be granted for the employment of counsel, and these will be looked at separately.
I appreciate that, but my point being that if a pursuer goes to a solicitor and says, well, I'd like to get counsel, it's not just a matter of whether the Sheriff would sanction counsel. If they're applying for legal aid, they've got to get through that first hurdle.
Indeed, that's correct, Convener. Or if it's a no-win, no-fee case, then the decision would normally be up to the solicitor with client's instructions whether to go to counsel.
Yes.
But if one doesn't know whether the cost of instructing counsel is going to be recoverable, then that either imposes a very significant risk on the part of the pursuer himself, who may have to put his hand in his pocket and pay it from his damages, or it puts the solicitors at a significant risk if they're going to carry that risk. I think my other concern is that the impression that I have gained is that, albeit Sheriff Taylor has suggested that the rule should be retained with an additional test of reasonableness, that the intention is that the rule may be interpreted more stringently, and that in cases up to a value of £150,000 there may be a considerably more stringent application of the test in deciding whether it's appropriate for sanction.
To move on more generally to the question of whether it's cheaper for cases to run in the Court of Session, cheaper in the Sheriff Court than the Court of Session. The Government's policy memorandum refers to one practitioner telling the Government that the average cost of raising a 3-day proof in the Court of Session was 30 to 40,000, whereas a 3-day proof in the Sheriff Court will cost around 10,000. Any general comments on that, particularly if counsel are not used and solicitors start conducting substantial value cases in the Sheriff Court?
I think to take one example as the basis for coming to a view is with respect to perhaps not the most helpful. I think it's undoubtedly the case that if counsel is not used in the Sheriff Court, then the costs will be less. And in general terms, the costs may be less in any event. But that is not the only issue. We are looking at access to justice and to the availability of proper representation for litigants. So whereas cost and proportionality undoubtedly is an issue, then we also have to look beyond that. I think to come to a sweeping view that in every case litigating in the Sheriff Court is cheaper is not, in fact, entirely accurate, because I think in the more complex cases, just take, for example, between £100,000 and £150,000, there may be very significant complexities which involve the use of expert witnesses, and counsel may well be sanctioned for such cases, and the cost can be significantly higher than might be anticipated.
Oh, I beg your pardon. Sorry, you get agitated. I missed you there. So I noticed then. Right, Miss Wood.
I just wanted to make a point about another kind of aspect of the reforms that we'll be going through, which is the increased use of case management as cases progress. And I think case management will be key to, is something that we welcome, and will be key to a lot of the practicalities about the discussions about sanctioning counsel. And I think we would always welcome that it was a consideration as part of the case management process as opposed to an assumption. I think if there is consideration for sanctioning counsel in an individual case as part of the case management process, then it will reduce the risk of sanction for counsel becoming a normalised part of the civil court experience. I think to normalise sanction for counsel without considering the individual case would undermine a lot of the changes that are being made, and could effectively bring the Sheriff Court to be the Court of Session by another name, which is something that we would strongly want to avoid. And I think, again, I would use the employment tribunal example in that. I think there are a lot of lessons that can be learned from that in terms of the increased use of counsel over time, and that becoming a normalised part of the process.
Thank you. Mr. Wolffe, you want to... well, I'll let Ms Clarke in
yes,
first. Have you already... Yes, Ms Clarke.
Sorry, I suppose I just wanted to add to that rather than... yes, I would support Lauren's point entirely, that rather than more counsel coming into the Sheriff Courts, what we would like to see is the other end of the process, much more ADR integrated into the system, particularly at the beginning, so that fewer people go in the court in the first place and they are able to access at the most proportionate rates. So really the opposite, I guess.
That was in the submissions. Thank you, Mr Wolffe.
Yes, and I should say immediately that I entirely support the appropriate use of ADR throughout the court system on that point. But I'm afraid I can't let Lauren's point about the normalisation of sanction for counsel pass. The starting point ought to be that advocacy is a specialist professional skill. That is why we require our members to undergo a course of intensive training in the appropriate skills which we consider appropriate to fit someone for that professional task. Litigants need effective representation, whatever the court or tribunal they're in. And that's the starting point from which, perhaps unsurprisingly, I view these matters.
I mean, some might say that, because we've heard an awful lot about the importance of counsel in the Sheriff Court, that that's self-interest, it's to do with income. I put it, well, it's a point that people would say, so I'm going to put it to you, know, that the loss of fee income to counsel, which is already, you know, quite under pressure, as I understand it, is even greater, and therefore it's self-interest that you would come here today as also the trade union leader for the bar to argue their corner.
I entirely recognise that I'm vulnerable to the he would say that, wouldn't he? And it is absolutely right that you know, our feature of these proposals, unless one's careful about it, and probably in any event, will be a significant impact on the independent bar in Scotland. And you know, I don't shrink away from that, but don't listen to me. Look at the submissions you received from the Educational Institute of Scotland, the various submissions you received from the union movement, Clydeside Action on Asbestosis. I'm quite content to, in a sense, allow them to provide evidence on the benefits that they perceive for those whom they represent in being able to have access to skilled representation through the use of counsel.
Mr. Tyler, you wanted to...
Yes, I'd just like to make it clear that the Society does not consider that automatic sanction for counsel should be available in the Sheriff Court, but for reasons of equality of representation and the ability of litigants properly to be represented in the appropriate cases, then sanction for counsel at an appropriate stage and with an appropriate test should be available.
On offer.
But, well, I think that the test, it depends how that test is applied and whether it's applied. At the moment, application for sanction in the Sheriff Court is almost automatic in anything that's reasonably complex at all. The question is whether in the new world the test will be applied in the same way, and the impression I gain is that the intention is to apply it far more stringently so that sanction will be granted on fewer occasions.
Thank you. I'll let John Finney, followed by Christian, please.
Thank you, Convener. Morning, panel. I have a question for Ms Wood, and it regards your evidence, Ms Wood, on the design principles with accessibility for users as a primary consideration. Now, you touched on that earlier. I wonder, could you expand on that? It's maybe not necessarily something that would be on the face of the bill, but particularly with regard to what you refer to as foster the easy promotion of peripatetic summary sheriffs, and why that would be important, please.
Many of the issues that come before, or that will come before summary sheriffs, are for lower value claims. Housing, well, parts of housing, when some housing goes to the tribunal, will remain as part of what summary sheriffs do. As part of the vision that we have for how a summary sheriff should practice to the best interests of the users of the system, we would think that they should sit out with court buildings. So you shouldn't have the example in Edinburgh Sheriff Court where to raise your claim for £400 back for a fence, you have to go through the metal detectors, you have to go through past the criminal courts, and it's a very daunting experience. So in terms of separating civil from criminal business, one of the ideals that we would see is that a summary sheriff should sit out with the court building itself. That would mean that, you know, sharing business with, or sharing premises with tribunals, for example, or perhaps court buildings, or perhaps even, you know, village halls up north would be possible. In terms of
its significance up north, you'll be delighted. I'm not allowed to forget the Highlands and Islands.
Or in the borders, of course.
It's all right, I don't need that, but he does.
Part-time summary sheriffs would also mean that in areas, or in rural areas particularly, where the need for housing, say, is worked out as, you know, half a day in one place, half a day in another that's 50 miles away, that could be facilitated. So you could have a sheriff that was a summary sheriff that was employed for 1 day a week, that sat for half a day in you know, Ballater, for example, and then half a day in Stonehaven if needed. It would take a very new approach to the system as it is in taking justice to the people as opposed to the other way around, but that's something that we would very much support.
We're doing the stuff on Sheriff Court closures that was put to the Cabinet Secretary about the Sheriff being able to deem a more suitable place to hear evidence, to hear a proof or whatever, and I think that was agreed at some point that there would be flexibility. John, remind me about that.
I don't recall it quite being that firm, convener, and I think, as Ms Wood said, it would be an attitudinal change that would need to be built on. But,
I think that attitudinal change would also greatly underpin the inquisitorial approach, which, as we also outline in the paper, we see as summary sheriffs very much sitting without wigs and gowns, but staying sitting without wigs and gowns, which hasn't happened in the small claims procedure.
Okay, thank you.
Anybody else want to comment on that? Nope. Right. Yes, Ms Clarke.
I was just going to say, yes, I think that's the consumer vision for these particularly small claims, is that we could access that.
Thank you. A question for Mr Tyler, if I may, and it's regarding the proposed abolition of honorary sheriffs, similar vein. Can you mention that in your evidence? I wonder, could you expand on that, Mr Tyler, please?
I think the concern is that in rural communities where there may be a single sheriff, there may not even be a part-time sheriff available or a summary sheriff available. If there is no availability of the honorary sheriff, then that is going to reduce the availability of swift justice being provided when it's required to the local population. So the position of the Society is that we would favour the retention of honorary sheriffs, but with legal qualification, so that that facility is available. And insofar as cost is concerned, that is cost neutral, because my understanding is that honorary sheriffs do not receive any remuneration.
Okay, thank you very much.
Thank you, John. Christian, please.
Thank you very much, Governor. Good morning. First of all, I would like to ask the faculty a bit of clarification. You said that clients have a choice to choose which court they bring to the Court of Session or the Sheriff Court, but you must provide, your firms you represent must provide advice. What criteria do we use to advise the clients in which court they should go to?
Well, at the moment, for any case above £5,000, the client has a choice. That choice will, and I should say I don't personally practice in the field of personal injury, so others might be better able to advise on that aspect of it than I am. The first thing I suppose to bear in mind is clients will first of all go to their solicitor, and the solicitor will take a view as to whether it's necessary, appropriate to involve counsel. The solicitor will advise the client on the pros and cons of litigating in the Sheriff Court or the Court of Session. Certainly in the commercial field, I would expect clients to be told about the relative cost implications, the relative benefits of, in the Court of Session, the experienced commercial court, which has got specialist judges who are there applying procedures that are intended to be business-friendly and the like. I think it's absolutely right to say that in the context of personal injury work, firms who represent personal injury claimants will routinely bring cases in the Court of Session, no doubt for a whole variety of reasons, including the benefits of the procedure that we've had there and the economies of scale that they can secure by litigating in, as it were, a single a single forum, but you'd be better to ask somebody else about that. That, I think, is one of the reasons why there's a desire to shift those cases into a national personal injury court, which is intended to replicate the same benefits of a centralised centre of excellence in personal injury work. And that's all very well, but the question that I'm posing is whether you actually will secure those benefits, first of all, unless the National Personal Injury Court is properly resourced, and secondly, if a key ingredient in what makes the Court of Session work, the involvement of counsel, is taken out of the picture, or at least is not being used in quite the same way. Fred may be able to say more about that.
I'll the first question, then come back in. Yes, Mr. Tan.
Well, I am a personal injury practitioner, and it's not my practice to raise very low value cases very often in the Court of Session. They tend to be higher value cases. But the principal reason for raising personal injury cases in the Court of Session is that the system is extremely efficient under the rules that were formulated by Lord Coulsfield some years ago. We have an experienced bar, an experienced bench, and experienced personal injury lawyers based in Edinburgh. There is very little judicial involvement in personal injury cases because 98% of them settle. Very rarely does a case actually have to come before a judge. And there's a relatively predictable outcome in Court of Session cases. As James says, the idea is that the new personal injury court should replicate that very efficient system and at lower cost, and that is to be commended. The problem is that, firstly, we don't know where the personal injury court will be. There is a suggestion it may be in Edinburgh. There's a suggestion it may also be in Glasgow. And we do not know, however, how that is going to work. We do not know, for example, whether solicitors in Aberdeen would prefer to use a centralised personal injury court or whether they would prefer to use a specialist sheriff within their own court. And if there are specialist sheriffs dotted around the country, then the predictability of outcome and the consistency of decisions will not be the same as it currently is in the Court of Session. I'm not arguing for a minute that we should leave matters the way they are, but I think there are some concerns that the new personal injury court may not be able to replicate what is a very efficient system in the Court of Session.
If I may press on that point, how much is the settlement figure a criteria of where to decide, a possible settlement figure, so a criteria where to decide the court should be taken? And is it the reason you propose a 50,000?
The decision on whether it's in the Sheriff Court or the Court of Session is quite straightforward at the moment. If it's £5,000 or under the £5,000, it must be in the Sheriff Court. Many practitioners will routinely raise relatively low-value cases, say between £5,000 and £10,000 in the Court of Session because of the efficiency of the system. Settlement sums tend to be very much less than the sum sued for, and it's the sum sued for which will determine in which court you raise the proceedings. So if I, as a solicitor instructed by the client, consider that the case is worth, at the moment, £6,000, I'm at liberty to raise it either in the Sheriff Court or in the Court of Session.
Yes.
I'd like to, I know, but I think I'd like to, there's other things we should really have asked you about which we haven't asked about, but after Mr. Wolffe, I'd like to ask something completely
I wonder if I
different.
might just make an observation on Mr. Allard's question. Mr. Tyler's, Fred is absolutely right that the criterion in the first instance will be the sum sued for, and that the settlement may be very much less than the sum sued for. Now, in our submission, we've, as it were, started from data about the settlement figure and identified the proportion of cases at certain settlement figures that can be excluded from the court. I recognise immediately that the sum sued for may be, in these cases, may have been significantly higher. That may be an issue in identifying the appropriate figure. What I do point to is that the bill itself contains mechanisms under which judges are to be directed to remit cases to the Sheriff Court if the judge takes the view that the case is of a lower value than the exclusive competence. And there are also signals that the rules on expenses will be used to discourage cases that shouldn't be brought in the Court of Session being brought there. Now, it's a matter of judgment whether one thinks that those measures will be in and of themselves sufficient to have that effect, or whether one has to go for a higher figure. And I think I've set out the faculty's position in the written evidence.
I want to just follow up on when you said about differing, perhaps, judgments by different sheriffs. If somebody decides to go to a specialist sheriff for personal injuries rather than to the specialist personal injury court at sheriff court level, will the sheriff appeal court not, to some extent, perhaps not immediately in due course, remedy this in that any appeals taken will be applicable Scotland-wide, rather than, as I understand at the moment, the sheriff principles would be only within the sheriffdom itself?
The difficulty is that only a very small number of cases will actually ever reach the Sheriff Appeal Court, as at the moment a very small number of cases go to the inner house of the Court of Session. I think at the moment the judges of the Court of Session are all sitting in the same place. They will no doubt confer in relation to the cases which come before them, and we have the specialist bar and specialist solicitors all based in one place. If there are little pockets of specialism at different places in the country, then I think our concern is that there will not be the same consistency as there is currently in the Court of Session, and which we would like to see replicated in the Personal Injury Court if it operates as it is intended.
But the Sheriff Appeal Court is not going to be...
I don't think that's going to resolve all the problems. It may resolve some issues, and certainly the fact that the decision of the Sheriff Appeal Court will be applicable throughout the country will obviously be of benefit, because it will be binding on all sheriffs, as opposed to the position at the moment where the Sheriff Principal only binds the sheriffs within his own sheriff.
Yes. John, do you want to come in on that, I think? Sorry, I hadn't realised it was you.
I understand that obviously the faculty, you don't agree that there should be what do you call it, a court for appeal. And however, following on from that, you may want to give your reason for that, but following on from that, I'm just wondering if would there be any implications for the European Court of Human Rights if this was agreed? Because my understanding is that if you're appealing, you go from the Sheriff to the Court of Session, and then you can go to the European Court of Human Rights. But that's, and then, so the point being then, would there be any implications if that were the case?
Yes, you're absolutely right that the faculty in its evidence expresses reservations about the introduction of a Sheriff Appeal Court. I mean, the oddity is that normally the Sheriff Appeal Court will sit, as I understand, as a bench of one, and that one will, as Fred observes, be in effect writing the law for the whole of Scotland within the Shrieval system. And there will be a possibility of an onward appeal to the inner house, but it will be through a very narrow gateway. And then, of course, if you do get to the inner house, you have the possibility of a further appeal to the UK Supreme Court. And once you've done all of that, then certain cases may go to the Court of Human Rights. I don't see any particular implications for the Court of Human Rights, but I suppose the question one might ask is what is setting up, as it were, two parallel structures of appeal within a relatively small country like Scotland. Does that actually structurally make sense, rather than routing all appeals to the Supreme Courts of Scotland to the inner house?
I take it you prefer 3 judges, as seems to me by rules of court, which was Lord Gills for the Sheriff Appeal Court.
Well, one of the occasional objections to the current appeal to the Sheriff Principal has traditionally been that you've got one judge sitting and deciding appeals from another single judge. Ordinarily, it's what one might think that having a larger bench in an appeal court is a good idea.
Thank you. I'd take Ms Wood. I'm going to, actually, Christian, after this, I really want to move another panel. You know what? I'm very sorry, we're so pressed for time, but I'll take Christian supplementary after I take Ms Wood, because you had another question. Yes. Unless you want to ask it now, because it might be the one you're going to answer, Ms Wood. Do you want to put it in? It was for?
No, I just wanted a quick question to Ms Wood. You talked about vision of what you would see the bill should be about. And you talked about, I wanted to know, do you think that the idea would be to have more people representing themselves? Is it that one of your views, and do you think this bill is bringing this idea to fruition?
I think that picks up on something Julia was talking about earlier, which we very much support in terms of the lower value claims particularly. Just now, it's not easy to bring a claim if you are a party litigant and you have and you know something's gone wrong with the work a joiner has done, or it's not a simple process. You know, there are forms to fill out that are quite complex at times, and when people have a crisis point in their life that leads them to go to the court for a resolution, in normal terms they might be able to deal with it. But when they're having to deal with something and it affects them that deeply, it makes it all the more complicated to fill in forms and follow the rules of court and that sort of thing.
Justice being different from access to have a solicitor or to have but
yes,
access to justice,
yes.
Being able to represent yourself
Yes.
will be a better way of accessing justice.
Yeah, particularly in the what will become simple procedure. The rules for simple procedure should be very easy for people to follow. What we would also envisage is as an information system as part of the Justice Digital Strategy, which includes you know, things like toolkits to lead somebody through the process, but which also outlines other pathways that they can go down. Court isn't necessarily the place that people want to go, and I think it is really important that as part of these reforms there are other options made available to people and embedded in the system, like alternative dispute resolution, mediation, online arbitration. There are a lot of other options that people could have.
I think I'd quite like you to expand perhaps in writing about in-court advisors, which yes. I think was very helpful to bring clarity and help to party litigants. Now we've got one final question, please, from Elaine. An important point.
About the issue of the time limits for judicial review, because currently there's no time limit. The bill proposes a 3-month time limit with judicial discretion to depart from that. Just when some witnesses are saying that's too short. So I wanted to invite your comments on that.
I think Mr Tyler and Law Society are
certainly. The position of the Society, I think, is set out fairly clearly in our written submission. And I think the concern is that if there is a 3-month period introduced, that period will be insufficient to enable litigants to do the necessary work and to obtain the necessary funding that they require to put in place before they can go to court. There are a lot of judicial reviews where claimants have to apply for legal aid. Legal aid applications tend to be relatively lengthy, and for the application to be granted, a certain degree of preparation requires to be carried out. Not all the preparation which would be required for presentation of the application for permission would be done at the stage of applying for legal aid. So the case would be front-loaded by the legal aid application and the necessary information for that, and only after that would it be possible to put together the case for making application for permission to the court. I think there are a number of other issues which we've set out in our written submission, and if I can expand further, I'd be happy to take that away and respond.
That would be very helpful. Thank you. Mr Wolffe, I don't know if the faculty took a view as such.
The faculty hasn't expressed any view, but perhaps I might be allowed to offer a couple of observations. The first is that in Scotland we have a very low incidence of judicial review applications, certainly compared with the position in England and Wales. It's not evident to me that we have a particular problem with judicial reviews being brought that should never have been brought. on the particular issue of time limits, there is a place for controlling judicial review applications on the grounds that they delay of the passage of time, and the current rules which are applied, which are a common law based on a common law doctrine known as mora, don't work well for a variety of reasons in the context of judicial review. So there is, I think, a sound justification for a statutory control where a case is brought after an inordinate period of time, or after a period of time that has prejudiced in some way the proper administration of the system. Concerns are being expressed about 3 months. It's a very short time relative to other time limits that we have in our system. Concerns have also been expressed, and there's evidence in other submissions about whether it's a time limit that can be applied to all types of cases, bearing in mind the importance of judicial review as the mechanism by which government and public authorities are held to account in the courts.
You don't want to nail your colours to the mast with an alternative time limit?
Given the fact that he hasn't expressed a view, I'm not going to offer one.
I want to thank you all for your evidence, and what I'm going to say is that if you wish to bring additional, having sat and heard the evidence here, if there's something you're itching to tell us and you've not had the opportunity to do, please feel free to write to us with supplementary evidence. I thank you all for it. I'm going to suspend for 7 minutes, 7 minutes or so. Right, thank you very much. I now welcome the second panel to the meeting. I was trying to work out what you call three sheriffs, a trio, a triumvirate, I don't know if sheriffs, but anyway, I very much welcome Sheriff Liddle, Sheriff Wood and Sheriff Colin William Pettigrew, all representing the Sheriffs Association. And thank you very much for coming. And can I go straight to questions from members, please? Elaine? Alison, thank you.
I wanted to invite your comments on a question I asked the previous panel, and that is about the concerns over the implications on the workload of the Sheriff Courts and whether or not the bill as proposed is sufficiently well resourced to be able to tackle any additional pressures that might be coming through because of it, and in particular whether having just 2 sheriffs in the personal injury court and only replacing or only bringing in summary sheriffs when another sheriff is retired, whether actually that will be sufficient, or whether you feel that, that in order to be successful, these proposals would have to be better resourced.
If you just indicate to me, microphone comes. Sheriff Wood, please.
Yeah, yes. Yeah. The bottom line here is we just need to be resourced, properly resourced, because there's going to be more business is coming our way, and we're happy to take it, but we need to be resourced, and it's really difficult to work out what the landscape's going to be in the next few years. But we're happy to take it. We want to be resourced because we provide a public service, and the public deserve a good service. So there's no point in overloading us and then we can't do the work. We're kind of busy right now with what we do. But things are going to change for sheriffs with the advent of summary sheriffs. And summary sheriffs are going to do a lot of the work that we do right now at a lower level. And by and large, sheriffs will just be doing solemn work, proofs, debates, fatal accident inquiries, family work, and also the opportunity of doing some appellate work too. So it's happy to do it, but make sure we're not overloaded, because that will just there'll be a backfire.
Expand on properly resource, please. What we're talking about?
Well, time to do the work that is required of us. So, I mean, a lot of the work that we do right now is volume work, and that's going to be, by and large, I think that's going to be taken away from us. A lot of the summary crime and the summary civil stuff and the small claims, that's going to be taken away from us. So there's a chunkier stuff for us to do, and we just have to be given the time to do it. It's difficult to be more specific than that.
The proposal at the moment appears to be that summary sheriffs will replace existing sheriffs rather than they'll be an additional to existing sheriffs.
I mean, I see right now we've got about, I think it's 141 sheriffs. That number will come down in time. I see this taking maybe 10 years, you know, that we've got the right complement of sheriffs and summary sheriffs. And so I'm not quite sure how that's going to play out, and it depends on one court to the next. I sit in Glasgow, and I can see in Glasgow that there will be so many sheriffs and so many summary sheriffs. It's a wee bit more difficult to work out what will happen in a one-person court, whether it will be a summary sheriff or whether it will be a sheriff. So it's interesting.
I hope the camera was on your end. I'm sure it was, because your sort of manners and facial expressions spoke volumes there. Before do any other sheriffs wish to come in and reflect and give us their general views on it? Yes, Sheriff Pettigrew.
I would endorse what Sheriff Wood has said. I think the question is whether the resources will be available to pinch a phrase that Mr Taylor used, front load the system. As I read the bill and as I read the proposals, the idea is not to front load. The idea is to progress. And I agree with Sheriff Wood, as it's looking at the moment, we're probably looking at a 10-year span. If you think about it, this Courts Reform Bill is not for 2014. It's for 2030. It's for 2040. You don't want to be doing this that often. And therefore, it is looking at the long situation. This will not solve the problem tomorrow, but it might solve the problem in 5 years' time. Clearly, if you want to solve the problem quicker, resources will have to be found. We, of course, have no control over those resources. We operate within the parameters that we have. But we recognise that simply substituting a new summary sheriff for a retiring sheriff necessarily will take time. And in the meantime, if work is coming down from the Court of Session to the Sheriff Court, then there will be a loading. And the question will be a question of man management, both by the Court of Session and by the Sheriff's Principal, as to how much can actually come down. The powers may be there, but it may not be as quick as the public or indeed this committee would wish.
Liddle, do you want to?
Yes, if I may, I think I may expand a little on what my colleagues have said. If it were the case that summary sheriffs were simply being created alongside sheriffs to split the workload and leave the workload as it is, then one would assume that other things being equal, no further resources are required, because we are able to do it within the resource fund that we have at the moment. However, at the moment, there is some quite severe difficulties in relation to, for example, summary trials being set months ahead, and for quite a lot of business going off because there isn't the resource to meet it. It is, I think, obviously the case that the more complex the work, and I mean here in terms of solemn criminal business as opposed to summary criminal business, and civil cases where the value is greater, that these are going to take up more time. They traditionally do. A summary trial can be through in half a day. A solemn trial is rarely through with 2 a week perhaps. And so it just is a matter of fact that the more complex the business, the more time is going to be taken up. If with the shift of business, which we do welcome, coming down into our domain from the Court of Session, from the High Court, it is more work that's going to be coming our way. And so that's really the point about resources. If we don't have the resource coming with us in terms of more sheriffs being available, more court time, more courts.
I was going to, just before you do it, I was going to ask, it may not be relevant, and if it isn't, obviously, please don't answer, but it was interesting, you're Glasgow Sheriff. Could you perhaps, would it be useful for us to know, because your experiences will be different ways of handling the business in your different courts, obviously from a rural and a very urban, busy. So, Sheriff Pettigrew, which is yours?
I think, Convener, you'll find that we're all urban sheriffs, albeit in different jurisdictions. I'm in Paisley. The Paisley buddies would say that's a long way from Glasgow. In reality, sometimes the boundary is very fine, and it's actually down the middle of Gap in Braehead. But to be serious for a second, we are a smaller court. Glasgow is obviously a much bigger court, and therefore I do have some experience of running a court which is slightly smaller. And it brings with it its own difficulties. We are under the new proposals to be a jury centre, and that will attract business, but we will also have the lower level claims that will have to be done. So my court, undoubtedly, like Sheriff Wood's court, will in the fullness of time have sheriffs and summary sheriffs, and it will ultimately be a question of management. And to pick up one of the things that I know the paper has talked about is I think there will be a management role for the sheriff within that environment to manage how the jurisdiction is divided between them. I know we may come back to that later this morning, because I think there are issues as where there are concurrent jurisdictions. Somebody has to allocate that business, and it will not be possible for the Sheriff's Principal to do that with all their other responsibilities. So, in my view, it has to be done by a sheriff, a senior sheriff, who will be able to look at the way the business is planned, and with the Sheriff Clarke, assist with the allocation across the board.
Sheriff Liddle, do you want to? Are you Edinburgh?
I am Edinburgh, yes. I've covered just about everything that a sheriff would be expected to cover with 13 years, nearly 14 years now. I have had a specialism in the family court for about a year and a half, but I'm no longer doing that.
It's just interesting because obviously there's a big range of what the different courts and the way. I mean, I went to Selkirk Sheriff Court once to find it was so small, all the criminal work was taken first, of course, and I was sitting there expecting to be like Edinburgh Sheriff Court with separate courts. So it's quite, there's a big range of what happens in different courts.
Using Glasgow as an example and bringing in summary sheriffs are only going to come in when sheriffs retire. So that's why I'm saying 10 years. And then you have to get the balance right to meet the workload. And can also say, I know this, we're talking about civil stuff, but we expect in time to be given increased sentencing powers. So that will mean a lot of the High Court work will come into the Sheriff Court.
Really, just to pick up on what you'd said about it having to happen over a period of time, I just wondered in terms of the exclusive competence for things like personal injury cases, should that be introduced more gradually, for example, or in a staged manner in order to be able to ameliorate the...
I think that needs to be staged so much. That's going to be done by sheriffs. And I think sheriffs need to be identified who are going to man the personal injury courts and who have got the right expertise and specialism to do that.
But some of them will be done by special sheriffs in the other courts, won't it?
Well, yeah, I mean, in Glasgow and in Edinburgh and Glasgow, we have specialists. I'm a specialist sheriff. I've done commercial court, and I've been sitting as a drug court sheriff for 10 years. But that's not all we do in Glasgow. I do that, but we all do other things. And I'm all for, if I can just say that, I'm all for specialism and expertise. But you've got to watch you don't de-skill people. And it means then that if you've got a sheriff and that's all they do and they become a one-trick pony, it's difficult to put them elsewhere where they need to be a bit more rounded.
It is a small supplementary.
Taking out the resource, you've mentioned time, you've mentioned case management. Is there a concern about the estate, given there's 10 sheriff courts to close, 3 already closed, 3 going to go in May, 4 in January?
There are mixed views on that. We've absorbed into Glasgow the district court, and that's put pressure on the building because there's the same amount of business, but there's more going on, and so there are only so many courtrooms. But we do have some concerns about some of the courts that are shutting down, and not just so much about that, but whether the courts that the business is going to can absorb the work, and without it pushing back dates and taking longer to get to hearings and to justice.
Yes, I think I would agree with that. There is a concern about estate. Edinburgh is perhaps a case in point, because we've had to pick up work that's coming out of other courts that have been closed, and Haddington is a very good example. We don't know how that's going to fit in. At the moment, we are running on pretty well full, so it is a concern. I suppose I would say that if the personal injury court were to come to Edinburgh, and there are people who have experience, the sheriffs who have experience in personal injury going back many years, but if that were to come to Edinburgh Sheriff Court, it's hard to see how that could be accommodated within the Edinburgh Sheriff Court building, and it may be that it would have to go elsewhere.
Like the Court of Session.
Pardon? Yes, by another name, Alison. I beg your pardon. Sheriff
I'm going to answer Mrs Mitchell's point. In Paisley, we also have the district court in, and we are basically running the full 9 courts 5 days a week, almost invariably. It will be a question of management, because if we are to act as the jury centre, which is the plan, and there'll be no juries in Greenock, all the juries in Greenock will come to Paisley. Whether the criminals will come up the M8 or not is a matter of moot point, but whether witnesses will come, whether jurors will come, there are all these issues. But in terms of pure estate, if we take out the 3 courts which are capable at the moment of holding jury trials, then they're not available for something else. And if you have a court, as I had yesterday, with 50 accused appearing, you need a big room. Otherwise, they're milling about the public concourse with issues of safety of the public, etc. And I was interested in the comment made by the lady from the Citizens' Advice in the last session. It would be an ideal world if we could separate the criminal and the civil. That is not possible in the estate which we have. And it must be a situation of trying to secure within the building as much division as possible. Because if you are coming to court as a civil litigant and it's the only time you go in the building and you're meeting, shall we say, some of the more regular customers, then it is obviously not something that will be amenable to access to justice. But in pure estate situation, there are concerns. I'm told models have been done. I know the SCS are working on that. But that is, again, a management situation, and it'll be dictated by volume.
Alison.
Thank you. Maybe a couple of follow-ups before I go into my substantive questions. Thank you. Sheriff Pettigrew, on that point, you will have perhaps also have heard Citizens Advice Scotland say that they're looking for a much more innovative and accessible approach for the new summary sheriffs, and they suggested sitting in the evenings and weekends and in non-court settings altogether. How do you respond to that?
The easy response would be to say, I'm a sheriff, I'm not going to be a summary sheriff, but that's a bit glib. I think if summary sheriffs are willing to and make themselves available as practitioners on a part-time basis, then they're likely to be more available in terms of time management to either sit out with what you would call the normal court hours or in buildings other than the courthouse. And clearly one should try and make the maximum possible use of the estate that we have. I understand that. And one is trying to do, in that sort of situation, run a system which is of help and assistance to the litigants. At the moment, if you're doing a summary cause or a small claim, in my jurisdiction, you have to be available on a Friday. Now, for very obvious reasons, I've had to discharge cases on a Friday when litigants, quite properly, because of their religious observance, could not come on a Friday and wish to be elsewhere. So those are management issues which would be looked at. So I think the flexibility of the summary sheriff, particularly if he or she is part-time. And the other situation is if he or she, particularly she is part-time, then you may open up the diversity of the judiciary more than there is at the moment. Because Sheriff Liddle and I were at a conference last week on judicial diversity to look at the role of, other than what one might call the traditional middle-class male, and opening up the judiciary to... well, I'm accepting that criticism, convener. I'm accepting that criticism. But opening up the judiciary, and if one, in a situation where you're out with the normal court hours, you may be in a situation where those who have family or indeed care responsibilities, we're now of an age where perhaps we don't have family responsibilities, but we might have responsibilities for senior relatives. We may have responsibilities for elderly relatives, so it's not necessarily gender specific, but those matters would be available if you took it outside the court hours.
Yeah. I would be astonished if the gender imbalance in the judiciary was down to there not being enough part-time roles, but I think there's a whole lot more at play than that, but I accept that.
If I gave that impression, then it was a misleading impression. I was not suggesting that. I was simply saying that would be one positive advantage that would be available. But I'm not for a minute suggesting that that is in any way the sole reason I would agree with you.
Gender balance around this committee today, and in fact it would have been 5-4 if Sandra had been here. So we do quite well in the Parliament, in the committees anyway. That's irrelevant, but I just thought I'd say it. Alison.
I don't know if the other sheriffs have any comment to make on Citizens' Advice suggestion of meeting out with.
Nothing wrong with the suggestions. They're good suggestions. It's just that it's finding the cost, but the funding to do that sort of thing, because it's taking it out with the use of the traditional court estate.
The other follow-up was you've said obviously that you foresee it taking 10 years, and therefore we're talking now about something that's going to be implemented in 2024. Is it ambitious enough? Is it possible to future-proof it that far ahead?
I think so.
Yeah.
I think so. It's just something that can't be done tomorrow. You can't flick a switch with this. There are some aspects that you can flick a switch, but you know, the changeover from, and we're all for a third tier of judiciary, but the changeover just can't happen like that. It takes time, because we have people in place. I suppose one way is that you know, packages are offered to sheriffs to you know, to go early, and that might accelerate it.
A couple of other points on the summary sheriffs. I note the Sheriffs Association themselves have said that they're concerned about the terminology, and perhaps it would be worth exploring why there are concerns about that and the confusion that there might be. And the other thing is to note that since the Gill review, the exclusive jurisdiction of these new summary sheriffs has expanded into family and children's Hearings Act, such things. So are you happy with that increase in the jurisdiction?
Yeah, I don't have a problem with that. I think it was Gordon or Colin raised it earlier. We will have concurrent jurisdiction in everything that summary sheriffs do. And if I can just, as I say, use family as an example, we don't need to do everything. That can be done at a different level by summary sheriffs. But I think there are some things which are particularly important. Complex removal of children, things that really matter, real family matters, that I think that a system has to be devised that the public can get the best service for these tricky things by sheriffs dealing with it.
If I may just make one comment through my family experience. If we take as an example a child welfare hearing, for the most part, one would say that they're fairly straightforward and could be dealt with by a summary sheriff, who after all is going to have 10 years' experience. It's the same as we have to have. However, there are cases which unexpectedly raise very, very difficult questions of law and become complex, and it's very, very hard to identify those cases in advance. You may have a case which introduces cross-border law, for example, relocation of a child, and you don't know when that's going to arise. So there will be cases, I would suggest, where you would want other than a summary sheriff to deal with it because of the complexity or because of the importance, and perhaps even importance in relation to setting down a precedent that may arise. The difficulty then is, how do you identify the complex case that should go to a sheriff, and who has the responsibility for routing that to a sheriff? And here I'm talking about gatekeeping. And it seems to me that one way of dealing with that would be to have the gatekeeping role, if there is a gatekeeping role, placed with the senior sheriff. And the senior sheriff would then be in a position to stream business that really doesn't require a senior sheriff to deal with it, but identify business which does require a more senior sheriff to deal with it.
As a supplementary to that, then, if a case has gone for a summary sheriff and during the course of evidence it transpires that this is much more complex, is there, I should know this but I don't, can it then be remitted to further up, as it were, to the sheriff to deal with? And that would seem to me quite difficult if you've part of the evidence has been heard by one sheriff and then you're moving on to another sheriff.
It may well be that that summary, maybe we're talking down summary sheriffs too much here, and if I've been doing that, if that impression has come across, I apologise. It may well be that summary sheriff is very comfortable and at ease with family matters, may have a background as a solicitor or an advocate in family matters. So, but I think that there might be, I'm not sure, I can't give you chapter and verse, but I'm sure there will be an opportunity to remit in certain cases.
To follow on from that, the interventionist approach, which was referred to by, perhaps you would advise us if you really act as referees, as is said, or find yourself sometimes in that position anyway, without it being in legislation.
Not for years.
I suspected that.
Yeah, it works, I think, and some sheriffs are uncomfortable in doing that. To some extent, I think it depends on your personality as to whether or not you can just kind of grasp things and kind of bang their heads together in a gentle fashion.
My goodness, you're scary. I'm getting scared. I don't want to be in front of this man ever in the wrong side of the box. Yes.
I think, Convener, the rules provide, of course, in the small claims and summary cause to a lesser extent that we are interventionists. So the existing rules do that. And on days that we're sitting, then we are much more encouraged to become involved, particularly with two-party litigants. If you have two-party litigants, they will think the case is about X. In all reality, it's probably about Y. They've never heard about Y. They have no concept of the legal parameters involved. So you do have to assist them. The one person, and I'm speaking personally now, not even on behalf of my colleagues, the one concern I have slightly about the bill is with the simplified procedure. As I read it at the moment, it talks about negotiation between the parties. Now, I have no difficulty in assisting parties to present their case. I have no difficulty becoming interventionist. I have no difficulty trying to identify the issues and then leaving them to tease them out. I have no difficulty even asking questions, as I do frequently in those proceedings, to try and assist parties. But I'm not negotiating, because in the end of the day, I have to maintain a neutrality And my only concern with the use of the word negotiation is that that's more a mediation situation. And if it is important and relevant enough, then there are in-house mediators that you were referring to the last speakers, I think, Convener, which one can refer and use. And they're not available in every court, but they are available in numerous courts. But for the judge, whatever you call the judge, summary sheriff, whatever, to actually negotiate, I think can have issues. Because if you are then ultimately the person who doesn't get the result they want, how much was the judge independent? And would that then reveal a plethora of unnecessary appeals to the Sheriff Appeal Court?
If I may, I think the language that's proposed in the new provision is to negotiate with. And although it's only a very small difference, there's a massive difference between negotiate with and facilitate negotiations between. And I think that facilitating negotiations between is something that those who have taken a judicial oath would be comfortable with, because you can do that and still maintain impartiality and ultimately deal with a decision if the negotiations fall through. But I think if you have crossed over into being involved in negotiations, then it would be difficult for that judge then to move on and impartially make a decision when you may have been involved in the actual negotiations.
Don Pentland.
If I could maybe go back to the resource implications again. It would appear on the surface that there's a high volume of work coming your way, and I think you did say earlier there that you're going to welcome this new business. But could you maybe identify any consequences or any concerns you have if you don't have the start-up cost? Because I would be of the opinion that if the start-up costs weren't available for you to carry out this work, could we perhaps see a court service going into meltdown or indeed a court service going into crisis?
Remembering that we're going to lose a lot of business, lose to the summary sheriff. So where it's difficult is to evaluate the size of what's coming in against the size of what's going out. And that's where I have my concern, is that we're pretty full on all the time. And then if what comes in is more than what goes out, the public will suffer and the court service will suffer. And the difficulty here is we're not flicking a switch. We're not bringing in a swathe of summary sheriffs now. It's going to take time, and maybe that's a good thing, that it takes time. We bed down and we understand how the mixing and matching is going to be. I'm not anxious about it. We just need to kind of suck it and see, and learn from it. And as I've said before, we welcome the changes. It elevates our standing as sheriffs, and giving us the opportunity to do stuff that's more challenging.
So you then telling the committee today, and you're giving us this guarantee that we won't have a court service in crisis?
I'm not giving any guarantees, but I'm happy to take it on.
Okay. But Sheriff Pettigrew and Sheriff Liddle,
I would endorse all of that. I think the difficulty is that in our individual courts there are individual pressures at the moment. It would be naive to imagine that in the short term those may not increase. I don't think they will increase to the cataclysmic effect you're suggesting, Mr. Pentland, but I think it's a question of management, and that ultimately comes down to ourselves as sheriffs, the Sheriff Principal and the SCS managing it in the best way possible, because in the end of the day we're all striving for the same result, which is access to justice for the public in a proper forum in a reasonable time.
To the senior sheriff you refer to would be within a sheriffdom, when you're talking about the management and assessing, there is no such, is there such a person?
Unofficial. In Glasgow we have
an unofficial.
The person who's been a sheriff the longest.
Right.
It doesn't make them any
right.
better.
Just to make it clear, that this is a sort of hierarchy.
But that doesn't, you know, they're more difficult. It's more difficult to have a senior sheriff when you're the only sheriff, or if
well, you
there
are
two
the
sheriffs.
senior sheriff,
Yeah.
de facto. Can I now move on to Roderick, followed by Margaret?
Could I just touch on, first of all, the Sheriff Appeal Court? From the government's, I think, explanatory memorandum, I think they anticipate that 5% of cases will be heard by more than one sheriff, and 95% of cases will be heard by just one sheriff. How do you feel about the proposals for the Sheriff Appeal Court, and how do you think that will work in practice?
Again, we welcome the Sheriff Appeal Court. As you know, there is a Sheriff Appeal Court anyway through the Sheriff Principal. And a lot of the stuff that the Sheriff Principal does are just interlocutory appeals, which really don't amount to very much. As to whether or not he needs to bring someone in to assist him to do the meatier civil appeals, that's really his decision. As far as the criminal appeals are concerned, I think that there's some value in having experienced criminally experienced sheriffs sitting alongside a sheriff principal who has only done, as far as being a sheriff principal is concerned, has only done civil work. So I can see the value in a sheriff principal sitting with one or two experienced criminal sheriffs to assist them in dealing with the workload.
Comment in the panel about the Sheriff Appeal Court. Don't.
Okay, a couple of other quick
course.
questions. Yep. Can I just move on to, we've had a written submission from Ailsa Carmichael QC, who's a part-time sheriff. She raises concerns about the place of residence requirements in the bill, which seems to enable the Lord President to make some provisions as to where a sheriff should be resident, and also not only in terms of practicalities, but she also raises concerns on a diversity issue. You were at the conference that you referred to earlier on. Any comments on the place of residence point?
Yeah, I think I would be happy to deal with that. There's the power to require a sheriff to live in a particular place, I don't think is a new power. And so that's a consolidation exercise. There are other consolidation exercises which I think are properly identified as such, with a change in the personality involved. It may be that what she was getting at, and if I could put forward an example, under the 1971 Act, there was a power, Section 10 of the 1971 Act, there was a power exercised by the Scottish ministers to require a sheriff to move out of a sheriffdom and into another sheriffdom. And there were certain criteria involved in being able to do that, which were by reason of illness or otherwise of a sheriff in another sheriffdom, or where a vacancy occurred, or where in any other reason it appears to Scottish ministers to be expedient. So there was a framework in relation to moving a sheriff from one place to another. And on the back of that, it would have been open to require residence under a different provision. Under the proposed legislation, which is Section 2, then the power is moved to the Lord President on his own to require a sheriff to move from one sheriffdom to another, into another court, in fact. There's no criteria set out in relation to that, so it may just be something that's been lost in the translation. I don't know. It may be intentional. But there is now no criteria for the Lord President to exercise that power to move a sheriff from one place to another place. It could be anywhere in the country. He also has the power to require residence, and as a matter of fact, in the most recent recruitment for Sheriff's Principal, it was made clear by the Lord President in the exercise of a power that he has that a Sheriff Principal wishing to be appointed has to live within the sheriffdom and has to be within an hour's drive of the base court. I can tell you as a matter of fact that that has restricted applications, because there are people, oddly enough, in diverse situations who simply can't do that. So coming back to the point about the ability to require someone to live somewhere, a sheriff to live somewhere, and the ability to move someone, I think that the Lord President has, for some reason, lost the protection that Scottish ministers had in using this really quite swathing power. Because under the old law, if ministers had decided that for reasons which were clearly set out, they needed to move a sheriff from one place to another, then that's something that they couldn't really be criticised for if it's been a proper exercise of the criteria. I don't see the Lord President being given the benefit of that comfort under the new legislation, because it's simply a power that's available and there's no criteria at all for exercising it. So it's a pity that he might be placed in a position, and I say he, this is for any Lord President, not the current one, but it's a pity that a Lord President might be placed in a position where they could be criticised without having to say, well, I did this under these criteria that were set out. But it may be lost in translation. I think if that weren't the case, then there might have been more comfort for temporary part-time Sheriff Carmichael.
Okay, that's helpful. And one final quick question. In terms of the simplified procedure, we heard evidence in the first session that the proposed limit of £5,000 is too restricted, and if we're making these changes, it should go up to at least 10,000. Any comments on that?
Well, I don't know if it's really for us as to what the privative jurisdiction should be.
Okay.
And it's a big jump, 5,000 to 150,000, and clearly it has significant implications for the faculty in particular.
No, I was talking about simplified procedure, not the.
But I think, Mr. Campbell, I think the same thing would apply. Yeah. Yes, I think my concern over the simplified procedure is not the financial limit, but the fact that most, but not all, of the housing cases are now going to be done in that way. We all sit in urban centres. We all have huge housing cases, case rolls, which will be benefited by the simplified procedure, undoubtedly. But it will also take a lot of time under simplified procedure to do it. But I don't think it is for us as serving sheriffs to, with respect, go into the policy as to whether it should be 5, 7.5, 10 or whatever. I do, however, firmly believe, and I think we all endorse this, that the exclusive jurisdiction at £5,000 in the 21st century is just inappropriate. But where it should be thereafter, I don't think it's for us as a body to pitch a figure. We will deal with what we're asked to deal with perfectly competently.
If I may, I would add to that the figure of £5,000 or any other figure is of necessity an arbitrary fixing of a figure. It doesn't necessarily reflect what happens in the small claim summary cause courts. And by that I mean that you can have the most difficult of legal questions arise with £500 at stake. An example of that would be if someone says, this plumber turned up and didn't do their job properly. All the lawyers know that that raises difficult questions in relation to professional competence under the Hunter-Hanley test, as it's known. Litigants don't know.
Thankfully, I don't know the Hunter-Hanley test, but we're not going to ask you to expand at the moment.
It's extremely difficult. I can expand on it actually very simply. You have to be able to prove that no person with the appropriate competence would have acted in the way. And a party litigant's got no chance of knowing that. The figure doesn't really, I don't think, matter very much. That's a question for policy.
Okay.
When we're on that, because I'm trying to find it in the explanatory notes and policy memorandum, that we got into this business of remitting from Sheriff Court to Court of Session and the test being higher now. Could you perhaps explain? I think we were told exceptional circumstances. It would be the test, as well as areas of complexity of law, but exceptional circumstances. What does that mean?
I think the difficulty in answering that question as a serving sheriff is that might vary from case to case, and anything I say this afternoon might be prescriptive, so forgive me if I don't answer your point direct, but simply to take the point, again, it seems to me to be a policy issue. If the driver behind the whole system is to create a collegiate appeal court, by which I mean the inner house, free up the senators for doing that type of work, to devolve the other business down to the sheriffs, which the sheriffs are perfectly capable of doing, and then to introduce below that a summary sheriff level. Clearly, you don't want a situation where, if any particular case is thought to be too difficult, it simply gets sent back to Edinburgh again. Yes. So it's not unreasonable, it seems to me, to have a change in the test. How that's going to be interpreted, I don't think I could comment on.
I just thought with your plumber, I just wondered if that might be an issue where it's such an area of complexity of law that there would be a remit to the Court of Session. But, it might arise. It's just whether it was a higher test now rather than specific examples. But you can't say that, of course, until you face it. Thank you. Margaret.
If I could ask your views on the provisions on judicial review. There's been concern about the 3 months period, that might not be long enough, for example, to get legal aid in place. The leave of court to filter out unmeritorious cases. Some people have suggested that isn't really a problem. And then if it is refused, the oral hearing with another judge and the inner house of court of session appeal that might go, some have suggested this is adding more expense. Any views on that?
They deal with judicial review.
You don't, right.
No, I mean it's going up to it's Court of Session.
So it doesn't come.
It doesn't really apply to us.
Well, can I ask if you've got a view on honorary sheriffs? Then there has been some disquiet about honorary sheriffs being abolished.
Your question, Margaret, it was yes.
To answer your point very simply, yes, I do. But I've read the Law Society memorandum. I think a lot of it makes very good sense. I think there will be in a country as diverse as we are with the geographical spread of population, if the office is simply abolished, as is proposed, although that wasn't originally what was suggested, and I haven't seen any justification as to why it's now being abolished. I may have missed something, but I haven't seen anything. It does seem to me to be a potential difficulty. There are situations, for example, in the court in which I sit, up until recently, the Sheriff for Campbelltown also sat in Paisley and went to Campbelltown as required 1 week. But we do need some judiciary the other 3 weeks that she's not there. And of course, the Honorary Sheriff is available to deal with matters that are immediate, that can't simply be transferred from the tip of the Mull of Kintyre all the way to Dumbarton. And if you do away with the Honorary Sheriff, quite simply, who's going to deal with that? If a sheriff has to be brought in or a summary sheriff has to be brought in, then there must be resource implications in terms of where the person is detained locally in the police station or wherever overnight. So I think for straightforward matters like that, particularly as I understand from the Law Society submission, that it's cost neutral. I can't myself understand, provided the Honorary Sheriff has a certain level of competence, and I think that was what was being suggested by the Law Society, then you're not getting someone who has no legal qualification. But that would be my view on that, Mr Mitchell.
If I may add to that, you may be getting, in fact, someone who has a very great deal of experience. I believe that one of the honorary sheriffs in Edinburgh is Lord Hope of Craighead, who is one of the leading judges of our age. And I also believe that Lord Mackay of Clashfern was one.
Have you, Sheriff Wood? No, I think the Sheriff would speak up if he wanted to, I'm sure. He doesn't want to.
Leave them be. Leave it be. Honorary Sheriffs.
Can I ask about the access to justice, which you've said that the allocation of sheriffs, summary sheriffs, should take out the needs of those living in remote areas and argue there's need for peripatetic summary sheriffs. Would you like to expand on that? Have we already dealt with that? Have I missed that? We haven't. Thank you very much, Roderick. I'm getting a compliment. I must mark the thing in my diary. Do you have a view about that? Because obviously there's concerns, particularly with closures and so on, that in rural areas in particular, the Highlands and Islands comes to mind. I say that for you, John.
Listen to the commentary earlier on. There's one observation I would make, and that is that if you require a sheriff to move around, then you have to build into that sheriff's available time, the time they're moving. That's not a very efficient use of that resource, but it may be something which is required. If you were, I think there was a suggestion I heard earlier on that you could maybe have a half day here and a half day there. So taking the time in between out of the equation, which may be longer than an hour, business just doesn't work that way. And if you turn up to a court, it may well be that the court collapses quite quickly, and it may well be that you're into multiple days. And turning up to a court in the morning, I would imagine, where there's a number of cases set down, because it's like a hotel booking system. You can't have one, or it wouldn't be efficient. And you have something which proceeds with witnesses hanging around, only to say, well, I'm really sorry, I can't continue this case into the afternoon because I've got to be elsewhere to maybe start nothing when I get there, but maybe we'll fix another day and come back. It could get into a bit of a mess.
The court system right now is not perfect, and there's a lot to be said in what's been suggested there, and maybe we should certainly not forget the needs of the public. So we have imperfections right now. If we were to have these peripatetic summary sheriffs, that might not be perfect either, but it maybe suit the public better.
Well, I've nobody else. Unless there's something you wish to say that we haven't asked you about that's within your remit. No.
I'd like to thank you for asking the Sheriffs Association specifically to come along and for us to give an input. We weren't able to do a written response. We did it to the consultation period. We just simply didn't have the time. But it's, we're very pleased to have been asked. I appreciate your time.
We also understand the pressure on witnesses to have their submissions in with the timetable that we've been given, which we've nothing to do with the timetable we were given, I hasten to add. So thank you very much for coming.
Thank you very much.
Thank you. Now, I'm just going to move on. Your papers for the next item, please. Okay, new set. Item 3, subordinate legislation, Prison and Young Offenders Institution, Scotland Amendment Rules 2014, SSI 24 and 26. You'll recall that we have considered this instrument twice. When we first considered the instrument, we decided to write to the Scottish Government on the lack of transitional arrangements on this instrument as highlighted by the Delegated Powers and Law Reform Committee. We also asked for their comments on similar concerns regarding the proposed draft Public Services Reform Prison Visiting Committee Scotland Order of 2014, which we considered late last year. Additionally, we wrote to the Association of Visiting Committees asking for their views on the concerns of the DPLR Committee. Having considered those responses, we wrote back to the Scottish Government seeking a response to the issues raised by the Association of Visiting Committees. The latest response has been received and is provided in paper 3. Do you have any comments to make in relation to the Government's response? I think it deals with it, doesn't it? It's pretty we've resolved it, have we not, Alison? Yes. So are members content to make no recommendation on this instrument? Thank you very much. Can I say that the order will continue to be assessed, and if required, included in the final version of the order, there will be, if required, any transitional savings. It will come up for us. So if you wait, we've got a backstop. I now move on to private session. And